I'm sorry, I was stuck in an administrative problem.
Made please, Lordship. Lordship, I have filed an IA in writ appeal 337 of 2022. Now,
Yes.
this appeal is fixed on next Friday. The IA should also come up along with this. Oblige, Lordship. May I please?
I hope there are no defects in it.
May I please, your Lord. I have also filed an IA, my Lord, on the writ appeal which is fixed on 8/12, my Lord. In the meantime, my Lord, some notice was issued for election on Friday, my Lord, I think.
Not Friday.
On 28, my Lord.
When
Because nomination is fixed, my Lord, on 2/12, my Lord.
2/12.
Yes, before that.
Come on Tuesday. Tuesday. Next.
May I please, Lordship? Lordship, I beg to mention item number 52 up to the daily list, Lordship. As the Angus Council is not well, Lordship, he is gone for a pressure stop, Lordship, and Islam. Item number 52 up to this daily list. Lord.
Who is for the government? Majmudar is there? Majmudar,
Item number 52.
though we are adjourning at his request,
My Lord.
get the original record to show whether they have actually served or not. That's the issue. The appellant was appointed. In her place already there was somebody working, and you appeared last time.
Yes, my Lord. Yes, I remember the case.
So bring
I'll get the
Then-
records.
because
For
if
that
she has
period.
not worked, then the scenario would be different. So please, he is asking for time, so we are adjourning it
My Lord.
1 week. Next.
My lord,
Repeat, Lord.
in item number 4, my lord, in today's list, my lord, an affidavit in opposition has been filed where respondent number 4 and 5, that may be called upon, my lord.
It is
One
at
sec.
2 o'clock in the chamber.
Yes, my lord.
We'll take up.
Yes.
Next.
May I please, your Lordship, I will to, with the consent of the other side, Lordship, I will to make an item number 50, Lordship,
Item number
50.
5.
Yes,
Yes.
Lordship, kindly, it may be fixed on 9 December, Lordship.
No, service to respond number 5 has not been affected.
I am respondent number 5, Lordship.
You are respond number 5.
Yes, Lord.
Then file your wakalat now.
Today file local number, Lordship.
Okay. You file it, it will be listed. It will be adjourned,
Yes, Lordship.
but not 9th December, some other date. Next.
May I please, your lordship, taking concern of the other side, your lordship, I beg to mention item number 33 of daily list, your lordship. Instruction is awaited, your lordship. Kindly grant 2 weeks time to file affidavit.
Serial number 33.
33 for respondent number 3.
Next.
May I praise the Lord. Lordship, with the consent of
Keep
the
your
other side, I
place.
will to mention item number 35, Lord. Lordship, they have filed their affidavit, Lordship. I am praying for 2 weeks time to file a rejoinder, Lordship.
January. Next.
Lordship, there is an interim order that may be
That
considered.
will be continued.
Observe, Lord.
May I please, your lordship? Lordship, I beg to mention item number 48. We need further time to file the amended petition on the PIL.
What's
Maybe
your
fix it.
request?
48.
Ah.
I've taken consent from the other side. So we paid for filing an amended.
That you are
petition.
doing it since long.
Lordship, it actually online it was showing us 29th November. So we are taking considering to file it on 29th, but it got listed on 23rd.
29.
Yes, Lord. Oblige.
Lordship, item number 7.
For 1 second. Yes.
Lordship, item number 7, the council is out of session. Kindly take up the matter on Friday.
We'll go to the next week. Next week.
May it please, your Lordship, I beg to mention item 44. The engaged counsel for respondent number 2 and 4 could not be here today. As today is order shot. We have the consent of the other side.
January. Next.
May I please, your Lordship? Your Lordship, I beg to mention item number 51 of daily list, Your Honor.
Yes.
And Your Lordship, the engaged counsel of this instant case is sick for last 2-3 days. So as such, kindly pray to list the matter after 2 weeks.
2 weeks.
May I please, your Lordship, I beg to mention item number 24, Lordship. Lordship, the engaged counsel is Mr. P. Purgas is out of station, Lordship. Matter will be passed over for 2 weeks, Lordship.
Here also Majmudar was to take instructions.
My lord, we have our instruction.
You have the instruction?
Yes.
2 weeks.
Yeah, please,
do
your
it.
lordship.
Obliged.
Lordship, I beg to mention item number 39 of the daily list. Lordship, we may be granted 4 weeks of time to file our impediment application, Lordship.
January.
My lord,
Give your
in
best.
respect to item number 11, my lord,
I told you.
my lord, 2 weeks time may be granted to file reply for item number 11. I am for the petitioner.
Next.
Obliged.
Your Honor, may permit me to mention item number 15 to 21. These are a batch of connected sextat appeal. On the last date, instructions were to come from the petitioner regarding whether they're going to proceed or not. I've been informed they are going to proceed and press this matter. But the matter may be listed because the arguing counsel based in Calcutta, we were not able to make arrangement on such short notice.
We'll give some date.
Any other date.
Mention
Yes,
it.
Lordship.
It was partly argued and we
It was
told
partly
Mr. Kyle to take instruction.
In July, it was out. So, Your Honor, the matter may be listed mid-December sometime.
We'll give some date.
Obliged.
Mid-December would be almost holiday. January. Next.
Your lordship, item number 12, with the consent of opposite party,
Item number
item number 12,
12.
with the consent of opposite party, the item may be fixed after 3 weeks. As one of our counsel is, could not come because of medical emergency.
It is covered against you by a Supreme Court judgment. It is
Pardon?
covered against you by Supreme Court judgment where you were a party before the apex. 2 weeks.
Obliged.
Next.
And I please, your lordship. But to be due concern of the other side, I beg to mention item number 32, my lord. My lord, my senior, he has some personal difficulties today, my lord.
You have to file affidavit.
The correspondence side, they have to file affidavit. There was a direction by this honorable court, my lord. They have not.
Yes, you have to file affidavit. No. R. Devi. 2 weeks.
My lord, I'm obliged.
Yes.
Item number 26, kasi matter may be adjourned for 3 weeks, Lord.
Beyond vacate. Next.
May I please, your lordship? I beg to mention item number 25, lordship. Lordship, matter will be taken up after a week.
Next week.
May I please your lordship, I beg to mention item number 42, finally adjourn the matter for today.
Yes.
Obliged.
Item number 1 to 3 of daily list.
My lord, before my senior begins, my lord, on 9/11/2022, my lord, 5 persons were impleaded as private respondents number 327. My lord, yesterday they contacted me, requested me to appear, instructed me to appear in the matter. But my lord, we have not yet got the petition. I'm praying for a short adjournment in the matter. I'll file my affidavit and thereafter the matter can be maybe taken up for final consideration, my lord. At least 2 weeks' time, my lord.
My lord, 2 weeks will be too much, otherwise admission will be over.
Because they
my
are
lord.
coming from.
No, my lord, I appreciate, my lord, there is nothing to file an affidavit. It's a question of law. It's already covered by division bench judgment. The moment the classification between miso and non-miso can't be made, that's the end of the matter. That is an issue already decided in the earlier round of litigation.
It is better if you.
No, my lord,
I'll file an affidavit, my lord.
No, it is better if you give an agreed date. So that
my lord, I can agree to witness them, not beyond that.
My lord, it would be difficult because they'll have to come from.
No, my lord, since they have taken, my lord, at times it has to be done. We appreciate in some matters. Also, we'll appreciate this matter after fixing the date of hearing. Then this notice was issued on last occasion also, we ourselves said, since they have just received.
Mr. Chaudhary, Wednesday don't keep Wednesday.
My lord,
Don't keep it on Wednesday.
Thursday, my lord, or Friday.
No, the bench may not be available.
Okay.
I might go to outline bench.
Let it be, my lord, on the week thereafter, my lord.
Then fifth.
No, my lord, fifth will be difficult. Let it be on my lord on first or second, my lord.
Not again. Next,
No, I am not here.
not here.
Fifth, my name.
7th, my lord.
I am not here. Mr. Chaudhary.
মোটর সাইডের কেস সাইডের কেস সুপ্রিম কোর্টের কেস আছে
Therefore, you told me 30 years. Therefore,
yes
still however, you are mentioning 30 years.
no my lord it said there is nothing to file an affidavit
me-
let my if he has got a copy
Therefore,
we'll
you tell me, we are ready for fifth. There is no difficulty. If there is no difficulty on fifth.
মই আহালৈকে তো কেসে নাথাকিলে গো
না না আছে বলে
anyway my lord I'll ask the client to engage somebody fifth I'm not there my lord.
Then sixth,
So my lord, sixth Supreme Court matter is there, fifth I'm going.
then when are you available?
Now I'll be back, my lord, on maybe 8 or 9. But by the time, my lord, the damage will be done. Let it be on fifth, my lord. I'll ask them to engage somebody else. That's why, no, lordship is not there on 30th.
30th, first and second, I may not be here.
Then let it be on 29, my lord. It's a question of law only, my lord. There's nothing like any affidavit.
Mr. Chaudhary, these matters will not be over within a day. That is the difficulty. Therefore, we are.
My lord, it will be over, my lord. I'll say, my lord, state has already, state has
No.
made the law, state
No,
has
no,
filed
no.
the affidavit. He is the beneficiary of a state action. If the state can survive on its own, it's okay. My lord, all that I'll submit is this is covered by division bench judgment. In the same bets.
You take some other date. Because I don't want to give date when I have to say that I am leaving early.
29 will it be inconvenient? my lord?
convenient.
Then. If then how about tomorrow?
Because we have already, Mr. Chaudhary, we have already said that this will be subject to further orders of this court.
Mm.
So that way you are not,
In that case, let it be on my lord 9th, my lord.
okay, 9,
Much obliged.
9.
Matter number 5.
Yeah.
Morning, Lordship. Lordship, this is an actually DRT matter. Only thing is that the honorable PO is absent till 24th. And e-auction is to be conducted on 25th. So that's why we have,
You go before DRT, there is nothing.
Lordship, the auction is on 25th and the honorable PO is on leave till 24th.
So you approach the DRT on 25th.
This is second auction, my lord. The earlier auction also.
we
they
know that.
managed, And that failed. my lord.
We know that. 24.
Pardon me. My lord, I'm told
24.
that he is on leave till tomorrow. He's expected to join on Friday. That is 25.
Nothing can be done.
Lordship, actually, I just want to say on the last occasion, actually, the honorable PO has asked us to deposit one amount. So we had deposited that. So if this auction is been continued, then we will be in a loss actually. And actually, my Lordship, there are two actually. One is of a house and one is of a factory. We are not concerned with the factory part. We are concerned about the house part. So for that, whatever the amount has been told by the court, actually, we have already been deposited. So if this auction continues and if someone strikes, it will be a little bit problem for us.
No 26. 226 out of first. These are all delaying tactics. What else?
The DRT can restore possession also. my lord. He can.
Whatever.
No, Lordship, the possession is already with them actually. We are just trying to save our house. Whatever amount has been said to us, we have been.
That is what we are saying. You are saying in a different word. We are saying in straight words that you are trying to delay the process of recovery. What else? Nothing. If you want an order, we may pass the order.
Okay, Lordship, then it's okay.
You want an order?
Withdraw with liberty.
I withdraw with liberty, my Lordship.
Next.
Number 6.
Yes, we have come against the order dated 20th of May, passed by the.
What is the tribunal? Tribunal has already provided in the order. Read
Lordship,
the
what
order.
happened, Lordship may come to page 6, paragraph 5.
No, you read the last part of the impugn order.
Yes, Lordship, that is correct. Thereafter, we file our WS, Lordship. But there is no
No.
division.
Liberty is however granted to respondent to seek modification, vacation of interim relief passed today.
No, Lordship.
Go there.
No, Lordship, we file our written statement, but there is a.
Written statement is not, Mr. Kyle, it is different. Tribunal is very clear in
No,
go
Lordship,
there.
we are not disputing that. There is not a division bench lordship for last many months lordship.
That is because of your client.
And lordship, he was
Somebody had come from Ahmedabad bench, I was told.
lordship.
Somebody had come from Ahmedabad bench. Mr. Bhairavia had come. Is he still available?
My lord, he was doing it online from Calcutta. He was in Calcutta. And one was coming, another administrative member from Bombay. Now a judicial member has joined here. my lord.
So you have to go there. Hold Mr. S.P. Kyle. Run a CGC for the
For GST department.
GST department. By way of this petition under Article 226 and 227 of the Constitution of India. The petitioner is telling the order dated 2/05/2022 passed by Central Administrative Tribunal Guwahati in OA number 111 of 2020. The proceedings of OA 111 of 2020 are pending at large before the tribunal. The order impugned is an ex parte, is an interim order wherein the learned senior central government council appeared and has accepted the notice. The matter was to come upon 11/7/2022, and while passing the order, the Honorable Tribunal has been pleased to observe that liberty is however granted to the respondent to seek modification / vacation of the interim relief passed today. In view of such clear observation, we do not think it fit to exercise our jurisdiction under Article 226 and or 227 of the Constitution of India, leaving it for the petitioner to file appropriate application for modification or vacation of interim relief. If any such application is filed, the same shall be considered by the tribunal as expeditiously as possible in accordance with law. And disposal of this petition shall not eclipse or prejudice rights of either parties before the tribunal.
Much of it.
With this observation, the petition is not entertained. Next, no cause.
Item number 8.
Mr. Chaudhary is there for the other side.
Lordship, he expressed some difficulty today. If it can be after 2 weeks, Lordship. He had informed me.
At the joint request, give some date. Next.
Item number 9 and 10.
Mr. Nair, who generally would oppose you in this group of matters?
My lord, the education department, the AG was appearing in the matter on the last occasion. Is it potential? Is it?
In this matter, the AG was supposed to appear, my lord. There is some difficulty, my lord, on his behalf, my lord. If my learned senior wants to start the argument today, my lord, let him start, my lord. We will, but there will be some difficulty on our part to conclude today, my lord.
He was just here.
Yes, my lord, he's gone to another court, my lord.
And he
There's some
should be here. He can go to other court.
Lord.
Since 2 days he was out of session. Today he was in my court and now he is out of court.
No, lordship, let my senior start, lordship. He'll,
You don't fix our timetable.
no, lord.
It is proprietary that a division bench should be shown by the learned advocate.
Yes, lordship, he'll be on the way, lordship. Let my senior start.
If you want to go on with the matter, call him. Otherwise, we'll adjourn the matter.
Today there might be some difficulty. I apologize.
Everybody has important matters. Not only even general advocates have important matter, and advocate general also has an important matter. He was just here. I can understand that he's on his leg.
Yes, lordship.
My lord will have it.
Lordship, I apologize.
Item number 13.
Want to take it?
May I please, yes, your lordship. Lord, petition against surface matter, my lord. And The property value of rupees 45 lakhs.
You go to the tribunal, mister. See this latest judgment of the Honorable Apex Court. Give it to him. There are 32 notes. It has come just last week.
And my lord, since 25 to 21, my lord, no payments. Even though, my lord,
Payment or no
Time,
payment, you read there are 32 onwards loudly.
paragraph 26.
One more matter of surface is there, it will also be covered in today's court.
The order of the tribunal dated 1st August 2022 was an appealable order under section 18 of the Surface Act. And in the ordinary course of business, the borrower's persons aggrieved was supposed to avail the statutory remedy of appeal, which the law under section 18 of the Surface Act, in the absence of efficacious alternative remedy being availed, there was no reason justification tendered by the respondent borrowers in approaching the High Court and filing writ application assailing the order of the tribunal dated so under its jurisdiction under Article 226 of the Constitution without exhausting the statutory right of appeal available at its command.
Therefore, here also, see, one-time settlement is not a matter of right.
In the earlier auction process, my lord, we have
And
withdrawn.
what is due and payable by you? 15 lakh.
As on date, my lord, 17 lakhs 36,000.
I had roughly calculated to 15 lakh, my lord. Nothing can be done. Lekho bhai, hold Mr. Have you deposited rupees 1 lakh of rupees?
Yes, deposit.
That was not deposited within 10 days, my lord, but it was deposited,
But it has been deposited.
my lord.
So that you can credit. By way of this petition under Article 226. The petitioner has. What is the stage of the proceedings under 13 to 13? What is the stage of the proceedings under the surface here?
Now it is installed.
My lord, that auction process we have withdrawn, my lord.
13-4 notice has been issued.
Issued, my lord.
So-
Auction was also carried out, my lord, but since there was a stay, my lord. Now we have withdrawn that earlier auction process, my lord. Now we will be going for a fresh process.
Has prayed for the following relief. Having heard the learned counsel appearing for the party. And also considering the earlier order dated 18/12/2020. It clearly appears that the appellant, as the petitioner, has an efficacious alternative remedy by way of filing an appeal as provided under section 17 of the Joint Right before the debt recovery tribunal. Following the decision of the Apex Court in the case of so-and-so versus so-and-so State Bank of Travancore in this recent judgment. As the alternative remedy is available, the petition is not entertained. Still, however, even while not entertaining the petition, the respondent bank is directed to consider the application for one-time settlement filed by the petitioner in accordance with law. Ad interim relief granted earlier, if any, stands vacated. Next.
Matter number 14.
The amount of rupees 1 lakh deposited as per earlier order dated 18/4/22 may be withdrawn by the respondent bank. Next.
The respondents were to file an affidavit in the matter.
Yes.
I have received the instructions. First, if you give me 2 weeks time, I'll come back.
At the request of. Next.
New petition or amendment.
Matter number 22.
My lord, appeal against order passed by the family court, my lord. It's an appeal under section 19 of the Family Court Act.
Between father and
Father and daughter, yes.
Father and daughter, madam.
try to resolve the issue.
My lord, my lord. Lordship may direct the parties to appear for mediation, my lord.
Mediation का order कर दीजिए. The parties shall appear before. The Guwahati High Court mediation
My
center
lord.
on 28
28th of November.
November.
Deeply
The
obliged.
matter be placed again before this court on 9th of December.
My lord.
Try
I'm
to
obliged.
resolve the issue. Next.
Number 23.
Yeah, please, Your Lordship. Petition against the rejection of the mutual divorce petition filed by both the parties, Your Lordship.
No, but she has withdrawn the consent.
Yes, she has filed a petition for withdrawal, Your Lordship. Your Lordship may kindly see her withdrawal petition, Your Lordship.
No, we are not concerned, Mr. The question is that the element of 13B is the consent.
Yes, and she filed the withdrawal petition after 9 months, Your Lordship.
Maybe, but before the cognizance was taken, you note down one judgment, AIR 1992, Supreme Court 1904.
Oh, I have also given one,
is
I have
on a-
annexed it, Your Lordship.
That is on a different point. We have noted you note down this judgment. 1992, Supreme Court 1904. And another is AIR 2012, Supreme Court 2890, notice for final disposal. This will help you.
But the judgment I have annexed, Your Lordship, that is clearly covering this.
It does not cover, it does not apply to your case at all.
She filed it after 9 months, and the allegation was that after filing of the mutual petition, Your Lordship, joint
We are
petition.
issuing notice only to find out some way out. Notice for final disposal after 4 weeks. Next.
Number 27.
May it please your lordship. This is the appeal preferred by the ONGC against the learned single judge's order. The learned single judge was pleased to set aside the so-called notice which
you are
we have
for
issued and no final order was passed.
You are for respondent.
I am for the appellant lordship, ONGC, Oil and Natural Gas Corp,
Now, Mr. Saikia,
lordship.
the only thing is the bare allegation is
Lordship.
that he applied for a post based upon a false certificate.
Exactly. Lord.
Now, who has adjudicated that certificate is false or not?
Yes, lordship.
Any
The
exercise was done?
The authority is DCI, Dental Council of India, MCI, and as well as
That we know. Who has come to the conclusion that it is a false document?
this is the issue is like this, lordship. It is whether it is false or not false, that is one issue.
No,
But
that
whether
is-
that is a recognized institution or not a recognized,
We agree with you.
Lordship.
Some adjudication has to be there.
some adjudication, lordship. Now under second rule 36, there is a process of inquiry. We have given him the so-called notice. He has replied. We have yet to pass a final order.
Therefore, you pass a order properly.
Yes, that is what we want from this honorable court.
Because he can't have the cake.
Yes,
and
lordship.
eat
That
it.
is why the earlier round was, it was a premature stage.
Huh.
The learned single just set aside as a so-called notice.
You are for the respondent?
Yes, Lordship. Now, Lordship, my senior Mr. TJ wanted some difficulty to reach your Lordship. Let us play pass over.
We'll take up after 2 weeks.
After
2 weeks.
lordship.
Next. At the request of Mr. Chaudhary.
Highly obliged, lordship.
Number 28.
Any material is there?
Yes, Lordship.
With ONGC to show that the I could not lay my hands to it, otherwise there is a judgment wherein the view taken is that the facts were like this, that a certificate was submitted
Lordship.
of having passed a particular degree from say Act Institute
Lordship.
somewhere in Karnataka or Andhra Pradesh. And then inquiry was made by the recruiting agency. And it came to light that that institute did not even exist.
Same situation here.
That is why it remained, but I could not lay my hands
And
to
that,
it.
that document is also there.
Therefore, that will
Yes.
that will require to
Yes,
go
Lord.
into-
That document we have annexed, it is in his possession also. He received it.
Next.
Highly obliged, Lordship.
Item number 28.
May I please, Your Lordship? Let the maternity fast work for 2 weeks.
2 weeks. Respondents are served to the department. Not. Nobody appears. PWD is there, finance is there. PWD and finance are there.
Lordship may grant us some time. I'll
Mr. Nayak would be appearing.
Mr. P. Chaudhary, he appears, Lord, possibly.
Then accountant general also is there. Huh? For AG. It is first returnable, so take in some.
Give us some time.
It is joint request. Next.
Bless me.
Item number 29.
Yes, Mr. Majmudar. You were to produce that original appointment
The
letter.
original records are on the way, but they had sent me a copy of the records of the school. By WhatsApp now, what I find is there are actually 2 joining letters. So I have called for the headmaster, the inspector of schools, and the headmaster who was at that point of time to explain how 2 joining letters could be given on the same appointment letter.
Monday.
Monday would be it.
Attendance is also main.
They are all coming, madam. All the original records have called
We'll
along with
look
the
into
headmaster
it.
and the
Without that,
One thing is that, my lord, earlier he has filed a petition, my lord, WPC number 3231/2013. That record may be called for. I have done to the submission made by the learned council.
please repeat the number.
3231/2013, my lord, WPC number
3231 of 2013,
my lord. He filed, my lord, Nijara Data versus State of Assam. My lord.
As well as the read petition, Malad.
Next.
2006 read petition.
Next.
Item number 30.
Lordship, this appeal is filed against order dated 30/9/2022. Passed in WPC 1900 of 2020.
Will issue notice.
Lordship, I have filed one missed case for stay of the whole case.
92,000 for SBI is nothing.
But your Lordship, this will become a precedent.
That
Where
is why we are
for the lapse of the customer, bank will suffer.
That is why we are issuing notice.
Yes. Order may be stated.
Then you deposit this amount in the registry.
The history.
Who is Mr.? Let them appear. No. Is there any recovery filed against you?
My lord.
Is there any contempt proceedings?
No.
Then why do you worry? Notice after 2 weeks. Next.
Number 31.
In this matter, the respondents are yet to file their affidavit. In 3 occasions, Lordship was pleased to give time.
Ms.
I'm
Bhattacharya,
appearing for Mr. P. Nayak, Lordship. Lordship, in this matter, we have filed our first affidavit. And unfortunately, in the first one, certain things were left. So, Lordship had asked us to bring on law, Lordship. But Lordship, we need some more time, Lordship.
2 weeks.
2 weeks.
Next.
Deeply obliged.
Deeply obliged.
Item number 34.
15. December.
I am appealing for respondent to instruction is awaited, madam. Until after 2 weeks, in the meantime, I will file my affidavit.
Next. At the request of so and so. Next.
Obliged.
Item number 57 of supplementary list.
Maybe I can. My lord, in this case, my lord, I have filed a caveat, my lord. But that caveat application is not available on file. And my lord, my name also is not reflected in the cause list, my lord. So, my lord. My lord,
Ask Mr. Mohammed to give.
My lord, we have filed the case on 21/11/22. When you filed caveat?
the caveat was filed yesterday, my lord.
That is right.
That is why. it
That's
is-
why. That's right.
You give him a copy.
Then at two payment, I have no extra copy at present.
You can give him during the course of the day. There is no.
Yes.
My lord.
Next week.
Next,
Next Thursday.
Obvious, my
Next.
lord.
Next Wednesday.
my lord, still may I expect because time has been given to convene the meeting. So some interim protection, my lord.
No,
in
my
that-
lord, at this stage, my lord. you
No,
can-
there is violation,
you can, my lord,
mandatory
applicable
violation
law,
of
my lord.
law, my lord. Section 15(3), there alternative remedy is there.
Next week. Next Wednesday.
Obvious, my lord.
Number 36 of daily list.
Pass over at 2 o'clock.
Number 37 and 38.
Wait, your lordship. The matter is otherwise ready for hearing, lordship. My only prayer, will be listed to hearing in the meanwhile. They're going to be directed to produce the records pertaining to the particular land, revenue records, lordship. That itself will decide the case.
To be placed in the hearing list. Next. We'll see that if we open the matter, record will be called for.
Lord.
Next.
Item number 40.
Lord, if a date may be fixed, if I may most humbly pray. This
Date will
matter
be
has been hanging fire since 2014.
We don't adjourn without any date. Any matter.
Obliged, Lordship.
Next.
In this case, record was called for lordship.
Yes.
Whether a written test was actually held or not, my lord. I have a report, the
We
original
don't
record.
want report.
No, no, it's not a report.
Huh.
The copy of the original record, my lord.
Huh.
I have flagged it, my lord. The copies I have given. This shows that there was a written examination held. Answer scripts were actually deposited with the police station for safekeeping. The flag mark portion lordship will find. On 4/11/2012. The original record, my lord, I apologize, it was sent to the earlier council, my lord, which is now misplaced, but these were records retained by the school authorities and the,
Now what is the finding arrived?
my lord, the finding arrived at was that the advertisement did not specify that the written test was required to be held. And therefore, the entire advertisement being wrong, the entire selection had to be redone. That lordship would find at page 47. Page 47, third paragraph from the top. Originally, the advertisement did not say that there would be a written
Who
test.
appears for the other parties?
My lord, for the private respondent,
Private
Nothing
respondent
appears.
not appeared, lordship, notice was issued.
Is it out?
notice could be issued.
Notice was issued, lordship, but he not appeared.
The order dated 5/3/18 says, at present, notice need not be issued to the remaining respondents.
Therefore, there is no notice. You Datta appears for number 6. And KP Pathak,
For him, my lord, I am appearing, KP Pathak appears to the department. I appear,
1, 2, and 3.
my lord.
So now who is left out?
Respondent number 6 perhaps left out.
No, number 6 is represented by you Datta.
4 and 5, my lord, the managing committee of the school, whose records I have just produced.
Hmm.
And the chairman of the selection committee, that record has been produced before lordship today. So
They appear before the learned single judge also.
We are the respondent, versus respondent in the single bench.
No, madam, they did not appear before the learned single day.
Hmm.
Because at page 45, it shows that the petitioner, standing counsel education, and for respondent number 6, that is for him, someone appeared, but the managing committee was not represented in the learned single day.
Who appears for the petitioner?
I appear for the education, madam.
No, petitioner.
For the petitioner on the earlier round, Mr. Ayuddin appeared, madam.
No, in this appeal,
Mr. U Datta would be there.
because those chairmen and all are not required at all.
They are not required, madam. The records I have just produced before the court. Their records are here before the court.
Ask Mr. U Datta to appear. Next,
I'll inform you.
6th of December. His name appears in the, you take back this record, Majmudar. The registry is directed to show. No, his name is there. You Datta's name
It
is
is
there.
there in the cause list, it is perhaps there.
Then you inform him, we'll pass over at 2 o'clock. You inform him, Majmudar. Because then the finding would be contrary to the record. Finding of the learned single.
Learned single just did not go into whether a written test was held or not. Advertisement did not specify that a written test will be held. Therefore, the advertisement was set aside. Consequentially, everything went.
I understand, but if this fact would have been brought to the notice of the learned single judge, the judgment might have been different.
That a written test was in fact held. Yes.
Therefore, prima facie, after hearing Mr. Datta and all two of you, we might even post this order and remand back the proceedings to the learned
I'll
single.
inform Mr. Datta.
Call him at 2 o'clock.
Number 41.
R3 is not solved.
Yes, my lord.
Huh?
On several occasions, my lord, we have been taking steps on R3. Now, my lord, Lordship may either await for further sometime or direct us to take steps, my lord, for paper publication, perhaps. Let us wait for some time. my
This
lord.
one number 3 is not being solved since long. The appellant shall take appropriate steps for substitute service by filing an appropriate application in this. The delay is enormous, otherwise we would have
Yes,
694 days delay.
yes. My lord,
Next.
with the R3, all others are represented, my lord.
Next.
Number 43.
To take steps. Next.
Yeah, please, Lord. So
You-
best step is taken actually today morning, Lordship. Better maybe on
Await service. Next.
Number 45.
Yeah, please, your lordship. In this matter, your lordship had earlier passed the direction. A part of it has been complied in regard to the status of Gitamundi Hill. But in regard to the steps that the government is going to take to preserve the Gitamundi Hill, in that
That is
regard,
not-
affidavit has
Mr.
not been
Pathak
filed.
goes to file affidavit.
short affidavit was previously filed by the department. The stand taken was this is the revenue.
No, that stand is that you have taken. Last time, if you recollect,
Yes, sir.
you have to file further affidavit.
Yes, I have communicated the department to the divisional forest officer of this range, your lordship. They are just because this area doesn't fall within the is revenue land. No steps had yet been taken by the forest department, but otherwise there is forest cover in the area. Lordship, what the officer had expressed before me was if some directions can be passed by a lordship directing us to take concrete steps, because since it's revenue land, if we go and take steps, your lordship, the local people will create a problem. So with the
then
strength of
the-
your lordship order, we can take some steps of.
No, DC can help you.
Yes, if your lordship directs that, your lordship, then we'll take steps. your lordship.
Bhattacharya ji is there. You
Lordship.
coordinate, you don't need any order from the court. Is not one department depending on another department for an order of a court.
Lordship,
Do
I
we-
can I would also like to request my learned friend if they can get some instruction, because there is a provision to declare such areas as
Yes,
deemed
yes.
forest.
Yes, yes,
Section 29 of the Indian Forest Act. Your
yes,
Lord.
you are absolutely correct.
Your Lord.
Therefore, you take, coordinate with both of you and take instructions. We don't need to pass any order on that.
Okay.
Chalo, next,
Draft 46.
await service.
I'm appearing for the respondent.
You are appearing for the respondent. Would you like to go for
Yes, Lord.
mediation?
Lordship, I'll file a reply, Lord.
Reply yes. We are on mediation. It's a matrimonial matter.
Lordship, a divorce has been granted, but the permanent alimony in respect, we are challenging the permanent alimony.
With regards to the permanent alimony.
We are conscious about it. Would you like to go for mediation and find out some way out?
Lordship, no, Lordship.
You are not. You will fight it. No problem. Next,
Item number 47.
here also service is not affected.
Lordship.
Await service. Next,
Item number 49.
yes, Dubey.
My friend is today.
Last occasion when I was sick, that is why.
No problem.
Well, in this case, well, we have already filed a petition in the tribunal, election tribunal, that is the district judges court. In terms of the act, the district judge is the election tribunal. So, well, perhaps my friend agrees if this petition, even the judgment of the single judge is in fact trustee.
So we'll say that now the issue would not survive.
Yes, ma'am. Nothing survived.
Or Mr. R. Dubey. For the appellant and Mr.
H. Omwa.
Huh?
H. Omwa.
For the respondent number 1. And Ms. Bhattacharya ji for number 1. By way of this appeal, the appellant has challenged the order dated 4/3/2022 passed by on a single judge in writ petition civil number 1494 of 2022. The respondent number 1 original petitioner had challenged the action of the respondent. Of the appellant. Wherein the order passed by the appellant dated 2/3/2022, rejecting the representation filed by the respondent number 1 was set aside. The control and counsel candidly submitted that respondent number 1 has already referred an election petition before the tribunal, that is district judge. In light of the aforesaid, the directions issued by the learned single judge are not required to be considered now, leaving it open for the parties to urge before the tribunal.
If your lordship pleases not.
The observations made by the learned single judge shall not prejudice rights of either parties before the tribunal.
My lord. I'm obliged.
With this observation, the appeal is disposed of. Next.
I'm obliged.
Item number 58 of supplementary list.
Item number.
This application has been filed, the IA is for condonation of delay in preferring the readable, my lord.
Sir, you are for the respondent?
My lord, I'm appealing for the respondent.
All
What, my lord, they have served us a copy of the condonation of delay. They have stated that it is 140 days. But what I find, my lord, the judgment is of 2019, 26/9/2019.
No, but the registry must have verified that fact.
Yes,
My lord,
from the
what
registry.
they
I
want
have.
to place it, what they want to place it that the period of COVID may not be taken into account. But the judgment of the Supreme Court as regards the point of limitation is, my lord, limitation period excluded which are within the period of limitation. If, my lord, take for instance, my lord, they
Mr.
have.
Counsel, if you want to join issue, you are welcome to file reply.
Lord, that is what I am placing, my lord.
No problem. So and so waves on behalf of the response.
But
When will you file the reply?
My lord, your lordship may give us 10 days time, I will file.
2 weeks. Next.
the contempt petition is filed in this case for alleging violation of the order. But in the appeal, we have also paid for stay. My friend is also appealing the contempt case.
My lord.
Next.
The number 53 of Delhi list.
Your lordship will not pass a stay order because, my lord, as regards he is praying for a stay order.
Contempt will also come before this bench.
My lord, no.
Lordship,
Before the learned single judge.
That you point out that we have issued notice.
Item number 53 of Delhi list.
Over to you, Neil.
May please, your lordship. Lordship, here the writ appellant has challenged the order of learned single judge. Let me, your lordship, brief the facts. Your lordship, the petitioner writ appellant were occupying the land since the year 1962, your lordship.
How did you come in possession of the land?
I was occupier, your lordship.
Answer straight. I am on the ownership part.
It's a government land.
Then you are an encroacher.
Technically, yes, your lordship.
There is only one type of encroacher, not technical or digital. The short question is this: we will permit you to argue. The land was earmarked for Government University.
It was a reserve land, your lordship.
Earmark or reserved, sir.
Yes.
Why do you go into what? What right you have over the land? There should be a title. Earlier petition says that you were to be removed in accordance with law.
Yes, your lordship.
Then
That has not been followed, your lordship.
accordance
And in
with
the
law does not
applies-
mean that घर पे आके तिलक करे जाए और बोले कि भाई अभी चलो.
No, your lordship.
Then what more do you want? You are there since how many years? Third generation. You are fighting.
More than 65 years. your
Then
lordship.
enough is enough. What encroacher can write? You should have filed a suit if you have any right over it.
Your lordship.
You are asking for settlement as if you have become owner. By adverse possession, you have to prove. You should have filed a suit if you claim adverse possession, though you have not claimed. I am adding to your contention. What right you have?
May I please, your lordship, I want to make one submission, your lordship.
You read para 9 onwards of the judgment, then I will permit you to make submission like that.
From the material placed before this court and after hearing the party, there is no manner of doubt that the land in question is a part of the land allotted to the Guwahati University. And from the pleading of the writ petition itself, the status of the petitioner as encroacher is fully established. The only right which the petitioner have tried to enforce is to treat them as a bona fide occupier who has been occupying this land for a considerable length of time. And therefore, before evicting them, due process of law should be followed. Through the division bench of this court in the case of Dhansiri Petrochem Supra has laid down that duration of occupation is a relevant consideration. The fact of the case is distinguishable as in this case, the
Now
duration
you
was more
pause
than
here
100
for a
years.
moment. With greatest respect, the apex court says that duration is of no consequence. Once you are encroacher, you have to prove your title. For that, you have to go to the civil court.
But your lordship, adverse possession doesn't lie against the government, your lordship.
I know that much law. Therefore, I am saying,
No,
if
your
you want
lordship,
some more time to evict, we may even without consulting
Yes, your lordship, that's
You-
what I'm praying. your lordship.
university, we can be lenient and put an end to this controversy.
That's what I want to submit, your lordship.
Vacate within 6 months, we'll grant you 6 months time. That much can be provided. We don't want to even ask the learned council. This litigation is pending since 2000. I'm sure you were not an advocate in 2000. Looking to your, if not anything, your black beard. So put an end to it. We'll provide that. Interim relief is already vacated in 2000, which was granted in 2015. What can be done? Encroacher is encroacher. Still, however, we will grant you some time. What are you doing in life?
Labor, your lordship. And your lordship, some of the petitioner has already been granted patta. One or
That,
two.
that may be in another land.
Your lordship, on the western side, the university has already erected a boundary wall. There is no.
Mr. Counsel, whatever may have been done in the adjoining land, university is not concerned. University can't say that you can be their neighbor. We understand that. The fact in your case remains that you are an encroacher, which has been declared to be so. Therefore, at the most, there is no stay granted in this appeal. Since 2019, you have continued. We may, till next summer vacation, you may continue. Summer vacation is from July, so for June, we are in end of November. So we may grant you six months time, vacate by 31st of May. Hold, Mr. You are Mr. Upadhyay. A. Upadhyay. For the appellant and Mr. P.K. Kalita, senior counsel assisted by you, Sharma, for respond numbers 1 and 2. Who appears for the government? You, P. Samra, for 3, 4, and 5. By way of this petition, by way of this appeal, the original petitioners have challenged the legality and validity of the order dated 14/5/2029 passed by learned single judge in writ petition civil number 86 of 2015. Following noteworthy facts emerged from the record of the appeal that the land bearing dark number 44 of village Uttar Jalukbari, Moza Jalukbari, came to be allotted to Guwahati University. It is the case of the appellant before the learned single judge that the appellants are in bona fide possession of the total area of about 1.5 biga of land out of the said land which was allotted to Guwahati University since last more than 25 years. The record indicates that, in fact, when the attempts were made to evict the appellant's predecessor, a writ petition came to be filed before this court, being writ petition civil number 2507 of 2000. And again, another writ petition being writ petition civil number 3194 of 2002. which came to be disposed of. On the bone of contention that no notice was issued as provided under section 18 of the Assam Land and Revenue Regulations 1886. And only a general notice came to be issued on 30th of December 2014. The present petition was filed. The appellants contended that they have a right over the land as they are as bona fide occupation since 25 years. And Guwahati University also filed an application or affidavit wherein it was categorically stated that the land in question is forming part of the campus of the Guwahati University and is clearly demarcated. The learned single judge, after considering the material on record, as observed thus, para 9 onwards. Mr. Upadhyay, learned counsel appearing for the appellant, candidly submitted that the appellants have no right, title, or interest over the land in question, but are bona fide occupiers, and therefore their case may be considered as similarly situated occupiers have been benefited by settlement order. On the alternative, Mr. A. Upadhyay further submitted that the appellants are poor laborers, and as they are in occupation since more than 25 years, some time, reasonable time be granted to vacate the land in question. On the aforesaid ground, it was contended that the single judge order may either be quashed or be modified. As against this, Mr. P.K. Kalital, senior counsel, appearing for the university, and Mr. P. Samra, appearing for the government authorities, have opposed the appeal and have submitted that the appellants are encroachers and have no right to occupy the land for any further period. It was further contended by learned counsels appearing for the respondent that as a university, the university requires totally encroachment-free campus, as the same hampers the other activities of the respondent university. So therefore submitted that the appeal being meritless deserves to be dismissed. Paragraph. We have gone through the record of the appeal and have also considered the observation and conclusions made by the learned single judge. Merely because it is averred that the appellants are in possession of the land in question since 25 years, the same does not create any right, title, or interest in the land as far as the appellants are concerned. The learned single judge has correctly come to the conclusion that the appellants are encroachers. Even Mr. A. Upadhyay and counsel appearing for the appellant have not been able to even remotely show that they are in possession under some order, right, or title. Under these circumstances, we are in total agreement with the observation made by the learned single judge, and no interference is called for. However, considering the fact situation that the appellants are in possession, and even these proceedings are pending since 2019 before this court by way of the present appeal, we grant time up to, we grant time to the appellant to vacate the land in question till 31st of May 2023 on condition that each individual appellant shall file an undertaking on oath before this court in this proceeding to the effect that they shall vacate the land in question latest by 31st of May 2023. Such undertaking shall be filed on or before 15th of December. If no such undertaking is filed, the respondents are at liberty to take appropriate recourse available under law. With this observation, the appeal is disposed of. Parties to bear their own cost. Next.
To number 54. Made to the lordship. But this matter pertains to recruitment by the authorities.
Who is for the government?
The government has.
Turn to page 80. You take your seat, Mr. President. 87. Annexure C of your affidavit.
Lord.
And read it loudly. What is your interpretation of this notice?
Lordship, as per government order number so and so
Little
dated.
slowly, because I could not understand, therefore I am asking you.
Lordship. As per government order number so and so dated 31st May 2019, in connection with the advertisement number so and so dated Guwahati the 7th March 2019 under portion Abhiyan for temporary and contractual post, a walk-in interview will be held on 14/6/2019.
Now you can skip the rest part is not according to me. Turn to one page less. Annexure A. That is 7th March 2019, whereby the candidate will be eligible for his own district only is provided.
Lordship.
Now this is the original
Original one,
original
Lordship.
advertisement.
Yes, Lordship.
The fact remains that the appellant applied only in walk-in interview and not in response to the 7th March. That is your case. But if you read what we have made you read, this walk-in advertisement is in continuation with the earlier. Therefore, all the conditions of that advertisement will travel with that.
Lordship, then annexure B may kindly be Lordship period.
That we have seen when we have
Page
seen this much.
86, Lordship.
Yes.
This
No,
is
that we are conscious.
Lordship.
But by this order of 31st May, which is referred to in the page that we made you read,
Lordship.
does not take away in its sweep the conditions of the main advertisement.
Lordship.
Otherwise, there was no sanctity of your mentioning 7th March in the advertisement at page 87.
That's true, Lordship, but
Therefore, who permitted you to dilute the conditions of the main advertisement? Take instructions. Otherwise, the recruitment may be in problem. Prima facie, we are against you. We are making it clear. It is misreading of the advertisement according to us. In such circumstances, we would quash the order and remand back the proceedings to the learned single judge to reappreciate it. But before doing it, take instructions.
Lordship, Lordship, I'll do.
Next.
To number 55 and 56.
Well, I have taken consent of my learned friend, Lordship, if allows on 6th of December, 5th or 6th.
Don't fix my timetable. I don't know what would be my position now in this.
For your lordship, I have given my submissions also in.
No, that we have seen
yes,
even yesterday.
because there are 2-3 points, your lordship, mainly with reservation, then clubbing. These 3 points basically which I am harping on in this matter. So, your lordship, since he has some difficulty, I'm accommodating. Otherwise, there is some urgency in this. On
That-
6th, if you're possible.
some date will be given. So how many JFOs then? How many JFOs do I gather? Enough is enough. Next.
Number 59 of supplementary list.
Much obliged.
Medical hospital madam. These petitioners, madam, they were working for about 3 decades, madam. Now they are getting full salary, all the benefits, just like a regular employee. Now they are saying that the time when they were appointed post are not sanctioned. And that's why, madam, they cannot be regularized, and so they are not entitled for pension. So this is the, madam, brief of that case, madam. Your lordship, in P.No. 336. And they are getting there also, madam, giving all the contributory fund also, their group insurance, everything they are, madam. Just like a regular employee, they are treated, madam. Regular salary also they are getting, madam.
No, but on what basis you say that regularization is available to?
My lord, my only question, my lord, that after taking my service of 30 years,
No,
all right, but regularize.
See, Mr. Mohammed, Mr. Chaudhary,
Well,
the question is that we can understand that you claim that these services should be clubbed as far as your pensionary benefits are concerned. Now that law is being developed, that if rules provide, then there is a Supreme Court judgment also recent. But regularization, the view taken is that irrespective of any number of years, regularization, there has to be some basis for that.
that's true, madam. I admit, madam. That,
Now, if you read para 15
yes,
of the judgment, there Upenda's judgment is quoted by the learned here, single judge.
paragraph, my lord. Yes, yes.
Even Uma Devi is quoted in para 14.
That is Umadevi is there, madam. We are aware of that, madam. Now, question, my lord, all right, you do not regularize me, madam.
So,
At least my service retirement benefits, my lord.
no, there is one more judgment where because of one OM,
Yeah.
it is not there in Assam. I'm talking of Gujarat.
Gujarat is judgment we are having, madam.
That PWT Employees Association.
Yes.
There are 2 judgments.
Yeah.
But there 171088 OM was there.
We don't have here, madam.
You don't have here 171088.
Yes.
There OM was there and OM is considered by the apex. There also I think 2014 SPC. There the view taken was that at the most they can be put on the minimum scale of the regular scale. But regularization was not granted to all. It was in phase 5 years, 10 years, 15 years, because that OM provided. Here in Assam, there is no OM.
This is from Gujarat High Court, madam. It can the Supreme Court also, madam. You lost kind of observation.
This is what the judgment I am
Yeah,
referring
madam.
to.
That is why also. I am not saying, madam, regularize all like that part, madam. Retirement benefit, madam. At least I may gratuity, deep encashment. That is I am entitled for that, madam. That maybe if that is done, madam, that will do, madam. Because they are getting the regular scale of pay.
Probably division bench order.
Madam.
I was party to the division bench order.
Yes.
Confirming learned single judges order.
Yes, the division bench, of course, we find it, madam. But the same order has gone to Supreme Court, madam.
Yes,
Single bench.
we are conscious about it. I was referring to this very matter,
Yes.
this very judgment.
Yes.
Pensionary benefits we can understand. But regularization,
That madam, because one already retired, madam. Number one, number one already retired. Number 3 means, madam, they are also, madam, almost going to retire next year or 2 years back.
therefore
Only retirement benefits, madam, that much.
you take instructions, Mr. Nath.
Well, the pursuant to your lordship, earlier order, my lord, I have taken the instructions and as regard the pensionary benefits they are submitting, my lord.
Yeah.
Lord, I have also gone through the judgment of the Gujarat High Court.
You can have it. We have got the copy.
Yes, yes.
So the,
Oh, you got it. Last time we have given to him.
yes, my lord, I have gone through.
And Nehal Singh also, my lord, that is also very clear, my lord, page 20.
The Supreme Court decision relied by my learned senior friend, my lord, in that case, I have seen the single bench decision of the Gujarat High Court and the division bench decision also. In those cases, my lord, what I have seen, my lord, the person was under government employment, my lord, and the rule provides that the pension is that is a pensionable service. And my lord, I have taken the single bench decision as well as the.
No, I am conscious about it.
Okay. And
That is what I was telling, that if the rules provide.
yes, yes. My lord, the
Pension rule, my lord, your lordship, if
for a moment kindly take up the single bench decision, my lord. Second page, para 3.
Mr. You take it that I am personally aware, my
No.
brother.
My lord. And vis-a-vis, my lord, the position here, my lord, the pension rules, my lord, in Assam.
Therefore, pension rules should provide like 2002 rules in Gujarat.
My lord, the pension rule here provides that the
it is
the-
there, my lord.
if lordship kindly takes up the pension manual. My lord.
Assam service manual.
Yes, yes.
Assam services
Service
pension manual.
pension manual, my lord.
Pension manual.
This one.
Yes. 31, my lord, police 31.
Kindly come to 32, my lord.
Page 32.
No, it is rule 32.
No, first 31, you lost kindness, my lord.
No, I'm just indicating. I'm just indicating.
Okay, all right, yeah.
Yes.
Well, kindly come to 32. The service of an officer does not qualify unless he is appointed and his duties and pay are regulated by the government or under conditions determined by the government. The following are examples of officers excluded from pension by this rule. Kindly come to example 2. Officers of granting aid schools and institutions. I'm indicating that they are under 80DA and admittedly 80DA runs on the granting aid of the government.
So they are excluded according to
excluded.
Assam rule.
As per the rules, they are excluded. Well, kindly, just for a moment, kindly come to the learned single judge has observed to that effect also. Lord. If Lordship takes up the appeal memo, Lordship, qualifying service. This is qualifying service. Sir. The service of an officer does not qualify for pension unless it conforms to the following 3 conditions. Firstly, the service must be under government. Secondly, the employment must be substantive and permanent. Thirdly, the service must be paid by government. But provided that the government may, even though either or both of conditions 1 and 2 above are not fulfilled, declare that any specified kind of service rendered in non-gazetted capacity shall qualify for pension. And 2 is the individual cases and subject to such conditions as he may think fit to impose in each case allow service rendered by an officer to count for pension. So these are if a person, in my respectful submission, if a person is serving in a regular department under temporary service, his period will be counted, and that to that effect there are some decisions of this honorable court. But the first condition at rule 32, and the second condition also ultimately it provides.
So how were they recruited?
Well, they were recruited, in fact, against the, that is another story, against some leave vacancy they were appointed. Orders are here. Well, the honorable single judge, while passing the order, has also taken note that this 80DA runs on the grants in aid of the state government. Lord. Kindly come to page 34 of the writ. Para 13. Para 13.
Yes.
On a query by the court, it has been informed that the respondent number 3 operates on the basis of grants provided by the state government, and thus such grant is inclusive of money against salary payable to the employees working at certified, sanctioned and retained post. So they are running on grants in aid. So the 32 excludes the person of the institutions who are running on grants in aid. If kindly takes lottery comes to the fund of the authority is also they are getting the fund from the government. So in my respectful submission as per rule 32, the they are not covered for pension.
Anything else?
But the
Either of you?
but the lordship has also directed me to update the information what happens to the other employees. That information Lord, I have received. Lord, I'm told that in fact as on today, the ATDA has been repealed, and the employees have been adjusted to Assam Plains Type Development Corporation and Bodo Kosari Village Welfare Autonomous Council outside PTR. Now ATDA is no longer there. And they said that the regular employees are getting revision benefit increment, and after retirement they will get gratuity and leave encashment. And ECPF that scheme is also available for them. And the pensionary benefit is not, otherwise they are not having the pensionable service. And the appellant, in respect of the appellant who are not in sanctioned post, in fact they are working not working in any sanctioned post, they are getting salaries at pre-revised rate and an annual increment at old. That aspect that may be considered because they are getting the pre-revised rate. And the ECPF they will not get, and no gratuity, no leave adjustment they will get because they are not in sanction.
Yes. Mr. Chaudhary, anything else?
Yes, my lord.
Hmm. One second, let me take it. Yes.
Firstly, my lord, is three conditions. First, practice must be under contract. Number two is substantial post as permanent. Practice must be paid to the government. Provided the type of that. Provided that government may either go either of both of the conditions for the foreign power of the field. Clear that any different kind of practice is help for type of. And if individual cases subject to such petition as he has made. For each case allows have been
So that discretion is there with the government.
So government can. That is what-
If they want to do,
Exactly. So that is part of the practice part of your worship. If you are taking survey, you are giving all the benefits. We are contributing to the contribution fund also. Right? Everything we are doing, man, just like a regular employee. Now, can you throw me out without anything, man, after 35 years?
you contribute to provident fund also?
Yes, man. We are 25%, 24% we are contributing. 24% to the contribution. Group insurance also. Everything, man. Yeah. Now, can you throw me out?
No, but Mr. Chaudhary, again, if we read this proviso Roman 1 and 2, it is with the discretion of the government.
That's
We can-
that's why your lordship.
we can direct them to consider your case.
That is what I am saying.
That is what-
Otherwise, madam, suppose by pension, I am not entitled. Gratuity, leave encashment, that's I am entitled. If that is also clarified, madam, that also to.
We'll look into it.
This rule 31 in my respective submission is in respect of the departments of the government. In fact, in this book of itself, lordship will find in the comments it continues to next page also. There are famous cases like Kabiram Rajbangshi and all these cases. Those were master role workers in PWD department. Their temporary service was directed to be considered, and accordingly they got the benefit. But this person, they are covered by rule 32. Under the chapter conditions of qualifying service, rule 30 and 31 indicate and the first condition, second condition, those are at section 2 and section 3. So this condition has to be fulfilled. Service under the government that has been explained here. So they are not serving under a institution which is a pensionable service. In fact, in para 13 of the judgment, the learned single judge judgment, the Honorable Court has also recorded that after that line I have already read. Thus, when the government has not created post of drivers for the establishment of ATTA, if any order is passed for regularizing the service of the petitioners, it would be additional financial implication on the state government. Then, in fact, from the ATTA, there were proposals submitted, but those were rejected by the government earlier. That post cannot be created, they cannot be given the benefit. In fact, when the institution is running on transit as per the rules, they have no right. That is my humble thought. They continue. They continue. It's a fact. In fact, but the instruction. Yes. If ECPF pension, but ECPF from ECPF pension, it's a nominal amount they will get. That they will get. ECPF pension they will. Employees contributory fund, provident fund, that from under that scheme, some amount of pension they will.
For order.
Look, yes.
ಈಗ welfare scheme ಮಾಡ್ತಾರೆ.
Yes.
But my entitlement is out of my service. Only at least part of the.
Let us see, we'll think it out.
Look.
Hold for order. 2:00.
May I please your lordship, lordship regarding item 29, I would like. Oh, sorry.
No, you tell us, no problem.
Lordship, regarding item number 29, I want to make a small prayer, lordship. We are appearing for respondent number 6. I'm appearing on behalf of an individual. Can it be taken on the 1st or 2nd December? Date has already been fixed on 28th.
You requested 2:00 because the other side may be there.
That's the lordship. Obliged, lord.
Mr. Mach,
On my lord, 20, your lordship has fixed on 28, my lord. 28, 29, I have some my lord difficulty. I told to the other side also, my lord. I have some my lord prior commit now personal work, my lord. He told me that your lordship may fix the matter, my lord, on next week, thereafter next week, 6, 7, immediate, my lord. As your lordship
if
available.
we have not signed the order, then it will be changed.
Yes, sir.
If we have signed the order, request on that day.
Yes, sir, my problem.
Majmudar is there in that matter.
Sign from Mutunda.
Huh? No problem. Pull out.
Letter number 4 of Delhi list.
It is in the chamber.
Girl has arrived.
We'll take up after the matter, sir.
Lordship.
In fact, it went out of our side. No problem. We'll take it in the chamber.
Number 36.
So, hold out twice. One counsel for the parties are not present. By way of this writ appeal, the appellants have challenged the order dated February 2007, passed by learned single judge in writ petition civil number 1797 of 2000. It is the case of the आगे लिखना है, as the matter is covered by the judgment of the apex court, we deem it fit to take up the matter for for hearing in absence of the learned counsels appearing for the part. As the matter is of 2008, as the present writ appeal is of 2008. The appellant associate approached this court by way of filing the writ petition inter alia praying for a writ order directing it order direct challenging the circular dated 5/1/2000 issued by phone number 4 here along with the letter dated 23/12/1999 and 9/12/1999. We learn a single judge by the impugned judgment and order. Was pleased to dismiss the writ petition and hence this appeal. At the outset, it deserves to be noted that the contention raised in this appeal is based upon the judgment and order passed by this court in writ petition civil number 5087 of 1999. During the pendency of this writ petition or a writ appeal, it was pointed out that the issue involved in this appeal is similar to the issue involved in special leave appeal in the bracket civil number 16431 of 2006, which was then pending before the Honorable Apex Court. And hence, this court passed an order of adjourning the writ petition signed again. The registry has placed on record the order passed in civil appeal number 1998 of 2020, 2007 dated February 19, 2014, wherein the Honorable Apex Court has observed the in light of the judgment of the Apex Court in so and so, no relief can be granted. It stands dismissed on the same reason. Stands dismissed. It is held that the in view of the aforesaid, no further orders are required to be passed. However, it is made clear that if any amount is paid, the same shall not paid towards local special duty allowance to local employees, the same shall not be required. The appeal is dismissed. However, there shall be no order is put forth. Next.
Letter number 40. The respondent number 5,
Which I am appearing for respondent number 5.
it is that it appeared for the lead petitioner in the original lead petition. I made a request to him to please the court safety.
Have you gone through the documents which is supplied? You take instructions because we intend to allow this appeal and remand back the proceeding. You try one instead of expert at the joint request. Send over to 5th of December. Next. So APS will take the APS in. Mr. Nath will take up the APS in chamber.